So Lucian, I know you've been staying on top of this Momofuku current events. Can you tell us a little bit about what's going on there?
It's been really interesting. The whole thing has played out in only a couple of weeks. 2 weeks ago or so, Momofuku sent cease and desist letters to some mostly smaller, mostly Asian brands that also make something that they call chili crunch. And I think most people would say that chili sauce, chili crisp, chili crunch is a staple of many Asian American diets. What happened though is that I think the big takeaway is that social media is unforgiving and very fast. Within a week, there was a huge backlash, which of course made Momofuku need to respond. Instead of pivoting, they tried to defend what they did. And of course, it's legal. Just because it's legal doesn't mean you should do it. They bought the Chili Crunch trademark from another company, and of course, companies are free to protect their brand. But in this case, the optics were terrible. It became a PR nightmare. And after defending themselves 2 days later, just last Friday, then they pivoted and said, "Oh, we're sorry."
That must be an older trademark, because nowadays it would be hard to get that through registration, given the fact that it seems to be a bit descriptive of the goods that it's covering.
I think chili crunch, I mean, just listen to it. It doesn't sound, it sounds like ketchup or mustard. But, this other company did get the mark. But 10 years ago, I'd say 10 years ago, there were probably only 500,000 or 600,000 marks applied for a year. Now, these days, are running more like 1 million marks a year. And the rates of allowances are going down, examiners are being tougher. So I don't think that would go through today.
Yeah. I guess it raises the important point of looking at not only what is legally the right path to pursue, but business-wise and PR-wise, does that track with the legal goal? And oftentimes it doesn't, and oftentimes you have to take a step back and say, even though I can do this legally, I don't think my client base and I don't think the consumer base across the board is going to like this decision.
That's absolutely right. And the vitriol that's appeared on social media is pretty incredible. A lot of people want to boycott Momofuku. A lot of people say they're not going to buy it anymore. And I don't know the numbers, but I'm quite sure that a lot of these smaller brands are seeing spikes in their sales and their visibility. An interesting angle to this story is that Momofuku bought the original Chili Crunch, and it's spelled Chile Crunch. And of course, many people now we spell chili Chili. And what they did was they also, after buying this trademark, they applied for a second trademark and said, well, we want to get Chili Crunch spelled with an I also. And we don't know how that will play out, because they're going to withdraw that application because they're not going to enforce this trademark anymore. But it would have led to some interesting musing at the trademark office, because the first one went through, here's one that's similar, what's going to happen? For these smaller companies, it's definitely a big win, because many of them already produce and market items that have Chili Crunch in the name. But there are other ways to kind of go about it also. A great example is Tabasco. Everyone knows what Tabasco sauce is and what it looks like, and that company doesn't have a trademark on the word Tabasco, and it does come from Tabasco peppers, I guess, but their trademark is on the label and the symbol that's on the label. And so you can trademark different items. One of the competitors, and probably the best known competitor to, and it's probably bigger than Chili Crunch, is a very old Chinese brand called Lao Gan Ma. And they have a trademark on a picture of like a grandma on the bottle.
So one of the things that a trademark examiner will look at, aside from some of the obvious things of seeing if there's any registrations or applications that are substantially similar to the mark, they'll look to see if the mark is simply descriptive of the goods and services that it's covering. We've seen over the last few years the bar for descriptiveness getting, I think, harder to overcome. Things that I don't think would have been found to be descriptive 5 years ago are now, we're finding that we're getting descriptiveness rejections. But an example of a descriptive term would be anything that, if just by looking at the name of the trademark, you can get a sense of what this mark is covering. The legal test is there an immediate understanding of some component of the good or service.
For example, this is a brown coffee cup.
Yeah.
Could you get a trademark for a brown coffee cup? Probably not, because it describes so many products. And if you got a trademark in brown coffee cup, you would get an exclusivity, a monopoly on something that many people produced. And so you'd be excluding everyone else who makes a brown coffee cup from being able to call their product a brown coffee cup. And in what we were just discussing recently, the chili crunch situation, well, chili crunch, it has chili in it and it's crunchy, so it sounds descriptive.